Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here today for the response from the defense team for R. Kelly in their appeal to the United States Second Circuit to get him temporarily released on bond. And if you guys recall, I did a video where they filed their motion. It was like 200 and some pages long. And then the Eastern District of New York responded. And so now the defense is coming back with their rebuttal to the Eastern District of New York. And I don't think that the Eastern District of New York can respond to this rebuttal. I think this is where it ends. And then the United States Second Circuit Court then can come back with a decision saying, yes, we're going to overrule Judge Donnelly and give him a bond, or they can agree with the denial of bond. And then at that point, I'm not sure how much higher the defense can go to argue this. At this point, it would really be kind of mute to try and take it any further, because the trial is set to start in September. And so you guys remember the initial motion to the appeals court came after the Eastern District of New York Judge Ann Donnelly, who's presiding over this case, denied the defense's motion to release him on temporary bond due to COVID-19 and the infestation in the prisons. And although I think the last article I read, they said like 5,000 inmates had been released. 5,000 federal inmates, I believe it was, has been released across the country due to COVID. But for some reason, they don't want to give R. Kelly any bond. And so this is what this is all about. And so the motion was 200 and some odd pages long. The response was 100 and something odd pages long. And so now we have dwindled down to 30 pages in this rebuttal. And about 6 of those pages is basically the cover page, the contents, table of contents, citing the different cases that they are going to use to support their argument, and then the closing page. And so we're going to go ahead and get started with this. Their first argument is that the district court clearly erred in denying Mr. Kelly's temporary release because he is eligible under Section 3114I, which is a code in the United States Code Book for federal cases. And so it says the right to consult with legal counsel about being released on bond, entering a plea, negotiating and accepting a plea agreement, going to trial, testifying at trial, locating trial witnesses, and other decisions confronting the detained suspect whose innocence is presumed is a right inextricably linked to the legitimacy of our criminal justice system. Then they cite some cases, and one of the things that they quote is, in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. These seemingly simple thoughts, that an individual is presumed innocent, that an individual should not be incarcerated people, he has his day in court, and that no matter how damning the allegations of defendant appear, he is entitled to a fair fight with adequate preparation, were seemingly wholly inconsequential to the trial court in Mr. Kelly's case. Instead, he is now facing a September 2020 trial date for which he will be completely unable to prepare in light of the COVID-19 crisis and the trial court's order requiring him to be detained. Here, the district court erred in denying Mr. Kelly's release because under Section 3142I, Mr. Kelly clearly met the standard for release. The district court ruled, I have found that the defendant has not presented compelling. Sorry, let me go back. So they're quoting what the prosecutors are saying in their response. It says, release is necessary in order. Wait a minute. I'm sorry. The government concedes in its response that a court may grant temporary relief pursuant to U.S. Code 3142I. The statute provides, in part, the judicial officer may, by subsequent order, permit the temporary release of the person in the custody of the United States Marshal or another appropriate person to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. While Mr. Kelly is arguably high risk for contracting COVID-19, he now has a confirmed diagnosis of diabetes. Okay, so this is something new. They're saying that he now has crossed the threshold to being pre-diabetic to being diabetic. The trial courts have generally not, as a trial court did here, required that a detainee actually be classified as high risk as a prerequisite to granting release from detention. Under 3142I, the question is whether release is necessary for the preparation of the person's defense or for another compelling reason. Accordingly, this court does not even need to research the issue of how the COVID-19 pandemic is personally affecting Mr. Kelly's health in order to determine that release from custody is appropriate. Release is clearly unnecessary for the preparation of his defense. So it looks like here they're going to drop this argument about COVID-19, which I think is a smart thing to do, and focus on the fact that the health issues involving COVID-19, but focus on the fact that due to COVID-19 in the prison systems, they have had to make all of these changes, and so it's pretty difficult for him to prepare for trial under these circumstances. So it looks like that's where they're going to move with their argument. And so they cite a case called United States versus Thornton, and it says suggesting that a district court can temporarily release a detainee pursuant to 3142I4 even after a prior order holding that the detainee was a flight risk or risk to public safety. And then United States versus Stevens, they cite a separate statutory ground for post-conviction release, and that defendants' inability to communicate regularly and effectively with counsel in light of Bureau of Prisons visitation policies satisfied requirements for release under 3142I. So it says the rulings speak directly to the case at bar because Mr. Kelly needs to prepare a defense for his two federal criminal cases in this judicial district and in the Northern District of Illinois. Other than writing that Mr. Kelly would have an adequate opportunity to prepare before his September 2020 trial, which seems difficult even if he is released and impossible if he is not released, given the current climate. The trial court did not even otherwise discuss or address Mr. Kelly's ability to prepare for trial and the impact COVID-19 in its last denial order of May 15, 2020. Presently, the Eastern District of New York case is scheduled for jury selection to begin on September 14 and for trial to begin on September 29, 2020. It is impossible for defense counsel to prepare with Mr. Kelly for that impending trial if he remains in custody. Add to the mix the fact that Mr. Kelly has literacy issues, which create an additional hurdle to trial preparation. And then point number 2 in the argument, Mr. Kelly's continued detention violates his right to counsel and right to assist in his defense. The government claims in its response that Mr. Kelly's assertion that his constitutional right to have access to his counsel and to assist in his own defense has not been, and then they have in parentheses, and will not continue to be, in parentheses, reduced, is without merit. That position entirely ignores and is contrary to the realities of the current situation. The government well knows and understands that Mr. Kelly currently does not have and has not had for a period of many months any meaningful access to his counsel and cannot, under the current circumstances, assist in his defense at all. It is incongruous that the government cites United States versus Shipp for the proposition the status quo is just fine, and thus state that every pandemic-era decision of which the court is aware has found that temporary restrictions on attorney visits and legal calls is reasonable in light of the global pandemic and the threat it poses to inmates, residents of New York City, and the nation at large, completely ignoring that immediately followed in that decision. And then they have a whole bunch of stuff here about that case. It says, finally, Mr. Shipp contends that his release is required under the Bail Reform Act, allows the court to permit the temporary release of the person if the court determines such release to be necessary for preparation of the person's defense or for another compelling reason. Pandemic-era decisions applying this provision have ordered the temporary release of a pretrial detainee when it was necessary to enable him to prepare for an imminent proceeding. And so it goes on, and it has some more information from several cases that were cited in that Shipp case. And so they're basically saying that the Eastern District of New York pretty much contradicts itself by citing this case. And so it goes on and says, as explained above, Mr. Shipp's trial is not imminent and his release would pose a danger to the community. Therefore, the court declines to order his release pursuant to 3142I. As with his due process claim, this analysis may change over time, and Mr. Shipp may refile his motion if a trial date is set and he is still unable to meaningfully participate in his own defense. And so they're kind of like turning the tables on the prosecution at this point. And so it says Mr. Kelly falls into the latter category. Trial is imminent and he cannot prepare. His situation is no different than the cases cited in Shipp, where release was ordered to allow the defendant to prepare for trial. There is no distinction between those circumstances and those that Mr. Kelly faces. The idea put forth by the government and agreed to by the trial court that a federal criminal defendant could prepare for this case with the restrictions now in place is entirely without merit. Frankly, Mr. Kelly could not prepare for a disorderly conduct trial with these restrictions in place. The reality of this situation is that none of his attorneys have been able to personally visit with him face-to-face for nearly 4 months. That is a situation that has existed and is expected to continue to exist, given that there is no certainty as to when the Bureau of Prisons is going to resume face-to-face consultations. One wonders how the government would like to prepare for a trial, any trial, let alone one of this magnitude, with mounds of discovery dating back decades, without the ability to sit down and speak with its agents, witnesses, or victims. That would never happen. And the trial court would never force the government to trial under such circumstances. It is an impossible task. And while the government seems to take solace in the trial court's consolation that the defendant and his lawyers will, quote, as conditions return to normal, have additional time to prepare for trial, end quote, the simple fact is that there is a September 2020 trial date fast approaching and no indication things are going to return to normal at any time before that. Even when things do return to normal, Mr. Kelly's attorneys are going to be amongst dozens of attorneys trying to personally visit hundreds of federal detainees. There is no chance of adequate availability for them to have the kind of meaningful dialogue required to prepare for trial. Certainly, there will not be an opportunity to make up for the lost 4 months. Coupled with the inevitable deluge of materials that the government is certain to disclose as the trial approaches, and notion that Mr. Kelly and his counsel will be able to adequately prepare becomes palpably fanciful. And so they're basically, once again reiterating that they haven't even received all the discovery yet. And that there's two Jane Does that haven't even been identified. So if they haven't received all the information on the people that have been identified, then they haven't received any of the information on the two anonymous people. So it is crazy to assume that they're going to be dumped with all this discovery, have an opportunity to go through it, and then meet with him to go through it and, get his information and, his recount of what happened and those type of things is just totally unreasonable at this point. And so it goes on to say the government and the trial court also seem to take solace in the fact, quote, he still has access to counsel via telephone, end quote. And for those of you just joining in on this whole thing about the appeal to the Second Circuit, in the government's response, they basically said that it's not their issue, that he can't meet with his lawyers because the MCC is under the control of the Bureau of Prisons and not under the Eastern District of New York. So it's not their problem. So it goes on to say, if not such a sad suggestion, it would be laughable. Mr. Kelly, like all BOP inmates, has extremely limited telephone minutes. Those minutes need to be used to, among other things, contact loved ones and family members. Obviously, those minutes do not go very far. To suggest that Mr. Kelly used them exclusively to call counsel would be to further cut him off from the rest of the world. More to the point, all of those calls are monitored. To suggest that he prepared for trial by placing hours of collect calls to his counsel a month and thereby not talk to anyone else, allowing the government to listen in on all those conversations is preposterous. How would the government like to have an arrangement where defense counsel can listen in on all of their trial preparations, which would be limited to 8 hours of trial preparation a month? Beyond that, Mr. Kelly must share that phone with all of the other inmates. Using a shared phone regularly goes against every bit of the CDC guidance in terms of COVID-19. True, there is a procedure in place for calls with counsel that are not monitored. As Mr. Kelly previously indicated, those calls typically range from 15 to 30 minutes, depending on the time slot assigned by the Bureau of Prisons. The way those calls work is that counsel contacts the staff attorney at the institution and advises that he would like to speak to Mr. Kelly. Usually within 24 to 72 hours, that attorney will respond and offer a couple of 3-hour windows during which Mr. Kelly's attorneys can expect a call. Once that multi-hour window is selected, counsel then must wait for Mr. Kelly to call during that defined window. Thus, it normally takes approximately 4 days or more from the time the process starts until Mr. Kelly's counsel receives the call. Again, counsel is competing with dozens of other attorneys who are also trying to speak to their clients, so the calls are infrequent. But even presuming that those calls could take place daily, Monday through Friday, which they cannot and are not allowed to, interaction is still quite limited, i.e. to a few hours per month. So what happens say they were to go this route, what happens if when he is allowed to make that phone call, the attorney isn't available, or the attorney can't answer the phone, or he's in court, or had a family emergency? Does the whole process start all over again? Like this is so crazy. I cannot believe that this is actually taking place. So it goes on and says, moreover, Mr. Kelly's counsel cannot review reports, documents, and other discovery materiality. Discovery materiality, Mr. Kelly over the telephone. Okay, I think there's a typo or a missing word there. Mr. Kelly's counsel cannot show him hotel records, flight records, business records, photographs, witness interviews, or any other materials over the phone. At the risk of redundancy, the government would never allow or agree to being limited to merely discussing by phone such materials with its own agents, witnesses, and in preparation for trial, nor would any district court ever require the government to proceed to trial under those conditions. Finally, the government downplays defense counsel's concerns about their own health and claims that those concerns are not ripe. Instead, the government suggests that the courts should wait to see, quote, when restrictions are lifted, end quote. Unfortunately, Mr. Kelly's attorneys do not have the luxury of that time to wait. They have an upcoming trial date and no lifting on detainee restrictions anywhere on the horizon. It is telling that most of the United States attorneys' offices across the country, including apparently the one at issue here, are not even regularly requiring or allowing their own prosecutors to report to work in person. They certainly are not sending them out to Bureau of Prison Jails and other places of detention. That is what is called a double standard. Okay. Moreover, to be clear, the concern is that regardless of when BOP reopens, Mr. Kelly's attorneys do not feel comfortable going right back into the Chicago MCC or any other jail for the foreseeable future. After all, Mr. Kelly will, on a daily basis, be in an environment of interaction with scores of other inmates and guards. Each of those individuals are going to be in contact with scores of other people. In other words, for counsel to meet with Mr. Kelly, they will have to run all the risks that he is facing. They will have to go into that cesspool of an environment to prepare for trial, risking their own health, and of course sit 6 feet away in a 10-foot room. The government's lawyers certainly are not being asked to do that and never would do so. Okay, I think this man is kind of upset with the Eastern District of New York and their shenanigans. And so he goes on to Section 3, which says the district court clearly erred in finding that Mr. Kelly was a danger to the community and a risk of flight because he met his burden by producing credible evidence that rebutted the government's presumptions. The two presumptions that Mr. Kelly must rebut are: 1, there are no release conditions that will assure the community's safety, and 2, there are no release conditions that will assure his own appearance. When the government can trigger a rebuttal presumption of danger and or flight, the defendant must produce some credible evidence that will rebut either or both presumptions. The burden of persuasion remains on the government to show: 1, by a preponderance of evidence that the defendant is a flight risk, or 2, by clear and convincing evidence that the defendant will endanger the safety of others or the community if released, and 3, that no conditions of release will reasonably assure appearance and safety. And so they quote United States versus Mercedes, noting in presumption cases, the burden of persuasion remains with government. The defendant, quote, bears a limited burden of production to rebut that presumption, end quote. The defendant's burden of production is, quote, not a heavy one to meet, end quote. Rather, any evidence, quote, favorable to a defendant that comes within a category listed in 3142G can suffice. United States versus Hammond. And so, point A, the government has not met its burden. There are serious questions as to allegations in the indictment. As to racketeering allegations, it is an abuse of the statute. It includes the alleging of consensual sex as a predicate act. The indictment essentially alleges that Mr. Kelly's own successful music career was a racketeering enterprise designed to obtain sexual partners. This ignores the fact that he made successful music, won Grammy Awards, and amassed millions of fans. It suggests that things such as the issuance of backstage passes and engaging in meet and greets with fans constitute criminal activities. It is a perversion of the purpose of both RICO and the Mann Act and surely extends the bounds of both. I like this lawyer. I like his wording, if nothing else. It says, with respect to the history and characteristics of Mr. Kelly, he has strong family ties in the community, has lived in the Chicagoland community for over 50 years, and has a perfect, unblemished record concerning appearance in court proceedings. Moreover, at the time of the current offense or arrest, he was not on probation. As to the nature and seriousness of the danger purportedly posed by his release, the pretrial services department is perfectly capable of monitoring Mr. Kelly and preventing him from contacting alleged victims. Moreover, the government likely has its witnesses tightly under wraps, being monitored closely by FBI agents and by victim specialists. Should Mr. Kelly even attempt to contact one of them, assuredly they would immediately tell the FBI or the coordinator, causing this court to revoke his pretrial release. And in this regard, the district court at one point concluded without any evidence that pretrial services were somehow stretched thin because of the pandemic. There is no evidence in support of this conclusion. Pretrial services in the Northern District of Illinois recommended release with conditions, while pretrial in the Eastern District of New York did not. There does not appear to be any reason. They did not explain one and do not appear to have one. Additionally, knowing he was under investigation in the Northern District of Illinois, he did not flee. Equally, or perhaps even more importantly, when he was indicted for very serious charges in Cook County, Illinois in the spring of 2019, he voluntarily surrendered the same day. When charges were added to that action and he was told that he had to appear in court for an arraignment on those additional charges, he promptly and voluntarily did so. Notably, the Illinois prosecutors did not even ask to increase or change any conditions of his bond at that time. Last, instead of using the last of his money to flee, Mr. Kelly posted a $100,000 bond in that case. Finally, because of the fundamental importance of Mr. Kelly's interest in liberty, they cite another case here. It says this court should also consider the length of his pretrial detention. And then they cite a couple of more cases. It says, noting that a substantial delay may require the government to make a heightened showing of dangerousness or risk of flight. This too weighs strongly in favor of Mr. Kelly's release pending trial. Mr. Kelly has already been detained for over 12 months. If his trial does not move forward in September, he could be detained far longer. Mr. Kelly undoubtedly has and will suffer a prolonged period of detention before a determination ever is made about his innocence or guilt. Notably, the Bail Reform Act is expressly not intended to affect the presumption of innocence, coupled with not having the opportunity to prepare for that trial with his attorneys. And that's under United States Code 3142G. And then B, there are a combination of conditions of release that will reasonably assure appearance and safety. The district court erred because it embraced the unfounded belief that Mr. Kelly is a risk to flee and that he would obstruct justice. It must be a serious risk of flight or of obstruction, not an ordinary risk. See Section 3142F. See also United States versus Friedman to suggest that he is a serious risk of either ignores the facts but instead relies upon speculation unfounded at best. As to the former, we have repeatedly pointed out to this court that Mr. Kelly has never missed a court date either during prior proceedings between 2002 and 2008 or during his current state case that preceded his arrest on federal charges. During the earlier state prosecution, Mr. Kelly was allowed to travel out of the country and return. The government keeps claiming that he obstructed justice in that case, implying that it is the reason why he prevailed. But the fact is that there was a 3-week trial with dozens of witnesses, including some of the same witnesses that are involved in the federal proceedings now pending. Mr. Kelly was very much at risk of going to jail during those proceedings and still showed up. Nor did he flee when he was charged in state court in 2019. Rather, he turned himself in after he was asked to do so. And he would have done the same here had he been given the opportunity. Further, the government has not presented evidence that Mr. Kelly has any resources to flee. Regardless of what he is receiving in royalties, that does not translate into resources. While the government points out that Mr. Kelly received approximately $200,000 each quarter in royalties, it fails to take into account the expenses he still has, including rent on the apartment he would live in if released, the warehouse he must maintain with all his touring equipment, employees and agents and attorneys who receive a great percentage of each and every dollar he earns. More importantly, the government cannot point to a single individual that would attest to the fact that he has ever expressed any desire to flee. To that end, the government cannot point to a single email or text message supporting its intent to flee theory. In any event, where could he possibly flee to? How would he go unnoticed? How would he have money to survive? Courts routinely point to the defendant's failure to appear in a prior criminal proceeding as a reason supporting the denial of pretrial release. If that is the case, then the opposite should also be true. Here, Mr. Kelly's perfect record of appearing in court should count for something. Any suggestion that Mr. Kelly would flee also flies in the face of the reality that it is virtually impossible during this pandemic to fly anywhere, let alone to do it surreptitiously. Airports these days are completely deserted. He could not just walk through an airport undetected or sit on an airplane unnoticed. He does not even have a passport. Certainly conditions could be fashioned that would ensure against any risk, including GPS or electronic monitoring, which would give instant notification if he left any premises. Now, although I agree he's not going to get on no plane and go unnoticed, and he ain't getting on no plane leaving this country, they do need to update that little part about the airports being deserted, because my daughter came from California. Her husband came from California. My other daughter has been to Denver, and I think she went somewhere else. But anyway, I know people who have traveled in the past month, and those planes have been to capacity. Okay, and if not to capacity, almost to capacity. I think Southwest is like the only airline at this point where they are not selling the middle seats on the flight. So they're, it might be 2 people on the row, but the middle seat is going to be empty on each section. So they need to change that up before they start coming with that nonsense saying that that's not true. So then it goes on to say the fact that there is no evidence he would flee and historically that he has not fled should be contrasted with the mere speculation that he would obstruct justice and flee. The government has repeatedly cited that factor, and the district court has repeatedly embraced it. However, Mr. Kelly must present a serious risk of future obstruction. Paradoxically, the district court points to the fact that Mr. Kelly is alleged to have obstructed justice in his literally decades-old state court proceeding in Illinois as a reason to believe he would obstruct now, while entirely ignoring the fact that Mr. Kelly always appeared at that very proceeding. Excuse me. Mr. Kelly's past behavior. Get back up here. Mr. Kelly's past behavior in the present case shows that he is unlikely to obstruct justice. One of the alleged Jane Does until very recently was Mr. Kelly's girlfriend. Although completely out of the norm, and even though she was an alleged victim, she was regularly allowed to visit with Mr. Kelly while he was in jail at the MCC Chicago and to regularly correspond with him. It appears that during an approximately 6-month time period, she regularly visited with him, corresponded via letters, shared emails, and spoke daily on the telephone. And see, right there, remember Greenberg came out and said, oh, he doesn't have email, he doesn't do this, and he doesn't do that. And so this lawyer, he's being more factual with the information. He's not showboating. And I don't know about these contradictions, like when Greenberg gets with the media and stuff and just be sprouting out the mouth and he's lying through his teeth. I don't think that helps R. Kelly in any way. And so it goes on to say, while Mr. Kelly knew that she was one of the Jane Does, he never did a single obstructive thing, given that she is now, and this is where it gets good, y'all, given that she is now, oh Lord, cooperating with the government, one would think that if there was any evidence of obstruction, the government would cite to it, and it has not. It never happened. Frankly, the idea that Mr. Kelly would now obstruct anyone is folly. The government has disclosed little evidence revealing the substance of its case, but what is known is that individuals are cooperating with the government and have had absolutely no contact with Mr. Kelly or anyone associated with him. That is not the case with respect to all the Jane Does. The government has not formally disclosed the identity of 2 of them, one of whom is his former girlfriend, who is continually on social media along with her parents, and there is no evidence that he or anyone on his behalf has reached out to her. Another is represented by counsel, has sued Mr. Kelly, and has appeared in Surviving R. Kelly 2, telling her story. All of that makes it extraordinarily difficult to believe that even if he wanted to, Mr. Kelly could somehow change her narrative. Another alleged victim is deceased, and Mr. Kelly has not had contact with the other alleged victims, if ever, for more than a decade. As for his now former girlfriend and present government cooperator, so y'all, we got a new name for Azrael. She's a government cooperator. She was still his girlfriend when he was arrested in this case. Although the norm is not to allow a federal criminal defendant to have any contact with witnesses in the case against him, she was allowed to have special visits with him while he was in the federal jail. They regularly communicated by phone and email. He knew that she was one of the Jane Does. There is no evidence he ever tried to obstruct or influence with respect to her portion of the indictment. He did not try to obstruct or influence his own girlfriend, and how is it at all credible that he would do it with someone else in the future? Lastly, it should be noted that the 2 co-defendants in the Northern District of Illinois including the supposed mastermind of the obstruction, were both released on bail without objection. Okay, so Darren McDavid, you are the mastermind of the obstruction, okay? To the point, the law speaks to the future, i.e., a serious risk that such person will, not that they have been. Regardless of the past, any evidence or concern of future obstruction is unsupported, notwithstanding years of rumors that Mr. Kelly was being investigated, television shows dragging him through the mud, and the filing of serious charges earlier this year in Illinois State Court. The government cannot identify any instances whatsoever where Mr. Kelly tried to influence, intimidate, or tamper with a single witness or potential witness to obstruct any current prosecution. Mr. Kelly is presumed innocent, his case is defensible, and he does not have any criminal record at all. Even when the government has satisfied its burden, detention should be ordered only if no condition or combination of conditions can reasonably assure the defendant's presence and the safety of the community. The question is whether there are any conditions that would permit release. Here, conditions can easily be fashioned. He can have restricted internet access and be required to wear an electronic monitoring bracelet. He can be denied the use of a cell phone. Further, now that different jurisdictions are involved in prosecuting Mr. Kelly, it is safe to assume that any witness that Mr. Kelly would attempt to intimidate would immediately call whatever law enforcement arm has been working with them as part of these prosecutions. Conclusion: the court should reverse the order of pretrial detention entered by the district court and remand this matter for the imposition of appropriate conditions of release. Respectfully submitted, Law Office of Thomas Farinella. And then it gives his address and everything and certificate of service. So guys, that was the rebuttal to the Eastern District of New York. He makes some strong points. It's a lot of redundancy, a lot of repeating what's already been said over and over, but I am happy that they're moving away from the reason to release him is for fear of COVID-19. It's still in there, but it's not the central point of their argument. Now they're moving towards arguing that even if COVID went away today, he doesn't have enough time to prepare for his trial because of this. And then I like the fact that they point out that, they're trying to impose these unreasonable conditions upon the defendant when they themselves would not want to work under those conditions. And I like the fact that he points out that they're not even going into the courthouse or going into the office, the federal buildings, to work on their cases, that all these people are working from home. So how are you going to tell his lawyers to go into the prison to meet with their defendant when you are talking to people on the telephone from the comfort of your home? So that was it. Let me know what you guys think. Do you think the rebuttal is strong enough? Do you think at this point, it's enough of the back and forth and just let the appeals judges decide? And guys, remember I told you it's not just one judge that hears this. It's more, it's a team of judges that will hear these hears these appeals, and then they come back with and I think it's a majority decision, sort of like the Supreme Court, where it's usually split by party lines, and whatever party is in, has the most. Like currently, the Supreme Court has more Republican appointed judges than they have Democratic appointed judges, and so most rulings do go in favor of the Republican side, of the conservative side. However, they do come out with rulings where they are able to kind of come to a consensus, along, just being a united court instead of being divided by party lines. So, I think he has a better chance with this of getting, depending on who the appeals court judges are, he has a better chance than having Ann Dunley, who's directly related to the case, who has a relationship with these prosecutors and is basically going to do whatever they tell her to do. So we'll have to wait and see. And once again, I don't know the time frame on when the appeals court will respond. I'm assuming, based on the nature of this appeal, that they will respond quickly if court is in session at this time. I'm not sure how the courts work. The appeals court works that way because, like the Supreme Court, they only hear cases certain times of the year. And what else? I think that's it. Just to wait and see what happened. And I don't think that the prosecution gets to come back and rebut. They might, but I don't think they do. I think at this point it's just waiting for the appeals court to come back with a decision. So that's it for me, guys. Let me know what you think. Leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.